people living in public housing to have guns. Jamie DeLine breaks down the ruling on a lease that would ban renters from discriminating against people who own legal firearms.
In a case called Hunter versus Cortland Housing Authority, 3 plaintiffs in the Second Amendment Foundation claimed the Cortland Housing Authority's lease violated the Second Amendment because it banned the possession of firearms.
Which means that if you chose to or needed to live in the CHA public housing, that you were completely stripped of your right to possess a firearm in your home.
The Housing Authority's argument stated that as a condition of living in subsidized housing, residents must sign a contract stating that they or their guests will not, quote, display, use, or possess any firearms or any weapons as defined by New York state law. The United States District Court for the Northern District of New York recently issued a permanent injunction in the case, siding with the plaintiffs.
Cortland Housing Authority has agreed that they cannot have a complete firearms ban for their residents in their lease. They have since changed the lease for the residents within the public housing, whatever public housing falls under their ambit.
The Cortland Housing Authority is also required to pay $150,000 for the plaintiff's attorney fees, according to the settlement agreement. Bill Sachs says this isn't the first time the Second Amendment Foundation has won a lawsuit similar to this one.
The courts have interpreted this issue very consistently that, you know, the government cannot, as a landlord, which is what they are in public housing, they cannot strip people of their rights merely as a prerequisite to getting housing.
I reached out to the attorneys for the Cortland Housing Authority, but was told they have no comment. Reporting in Albany, I'm Jamie DeLine.
The State Department of Agriculture is warning